are protected each and every day in employment, housing, public accommodations, and state contracts. We have approximately 29 dedicated employees at our agency that cover the entire state of Maryland, right? So you figure Maryland has about a little less than 6 million people, right? We got 29, right? But of those 29, they work tirelessly. From some get in as early as 6:30 in the morning, some leave as late as 7:30 at night to ensure that whatever issues people are having throughout the state of Maryland, we're addressing them as best as we can. The history of MCCR. We were created in 1927. I won't go over all this because I just briefly, I know we kind of short on time and we got started a little late. But we started in 1927. We were created as the Interracial Commission of Maryland. In 1969, we were renamed the Commission on Human Relations. Now, at that point in time, we were fully staffed and empowered to initiate and investigate complaints in state agencies. So you figure for about 40 years, we couldn't even investigate and do complaints, right? So that was recently added in 1969. In 2001, we added sexual orientation and genetic information to our protected classes. In 2011, we were renamed to what we are now called the Maryland Commission on Civil Rights. So if anybody asks you, well, what's the difference between the Maryland Commission on Civil Rights and the Commission on Human Relations? Nothing, right? We get a lot of questions that people say, well, I contacted the Commission on Human Relations. We're like, well, that'd be us, right? So we are the same agency. Some people get it misconstrued because we did change names, but we're still the same agency, same mission, same vision, same people. In 2014, as many of you I'm sure are aware, we added gender identity to our list of protected classes as well. The areas of protection that we currently do are employment, housing, public accommodation, and commercial non-discrimination. In employment, again, our employment is to ensure that everybody has equal opportunity in employment. Now, our jurisdiction is only for employers that have 15 or more employees. There are some local jurisdictions that cover a little less, cover 1 or more, but we only cover employers that have 15 or more employees. So that's key to understand. Anytime you're contacting us in reference to an employment complaint, please ensure that, again, that employee has at least 15 or more employees. So anybody know the protected bases that we cover in employment without looking on the sheet that you have? All right? Y'all cheating already. All right? Anybody? Anybody? I'll pick. I don't mind. Race. All right. Anybody else? Gender. Anybody else? Tashella? You want to name one?
Oh, nationality.
Anybody else? Disability. There's no right. I mean, I'll tell you if you're wrong. Don't worry.
Age.
Maybe housing and jobs.
Okay. Anybody else? Now y'all looking at the screens. Y'all cheating again. So these are the bases that we cover in employment: race, gender, sex, age, national origin, religion, sexual orientation, genetic information, and color, disability, marital status, sexual orientation, genetic information, and gender identity. Can somebody tell me a difference between gender identity and sexual orientation?
Sexual orientation refers to who you fall in love with or who you're attracted to, and gender identity refers to how you see yourself.
Exactly. So gender identity is who you identify with. Sexual orientation is who you're attracted to. There are a lot of employees and employers who kind of get confused with the two terms. For color, so can an African American discriminate against another African American? How? And in reference to color.
Colorism.
Okay.
People, both African Americans who are of a darker color, face more discrimination than people who are of a lighter color.
That's why you sitting on the front row. That's why you're sitting on the front row. All right. Moving on. Housing. Again, housing. What we want to do is ensure that we prohibit discriminatory practices with respect to residential housing by any purpose, to ensure that everybody is protected and can enjoy the peace, health, safety, prosperity, and general welfare of their housing opportunities. The protected classes that we have in housing. Anybody want to take a guess? We'll be covering housing. Kara?
Oh, sure. Age?
Sure. Anybody else?
You guys do,
You didn't answer by 2 questions already.
I had a question. though,
Sure. What's your
whether
question?
one of them is HIV and AIDS,
Disability is one.
so that's under disability?
Yes. Anybody else?
Family status?
Familiar status? Did I hear that? Okay. Anybody else? As you can tell, I'm an interactive person, right? I can talk all day to you, but some of you probably fall asleep. You've been working all day, right? Some of y'all probably had a good lunch, right? Or late lunch, or if you had lunch at all, right? So I do like to be a little more interactive. So let's work through this with me, and let's see what we get out. Anybody else? All right. Well, we can go on. National origin, religion, gender, sex, color, sexual orientation, disability, mental or physical, marital status, familial status, and gender identity. Public accommodations. What we want to ensure through our public accommodations jurisdiction is to ensure that all individuals have equal access and services to public facilities, whether it be a public building, retail, shopping center, or anything of that nature, anything that has public access. We want to ensure that everybody has equal and fair access to those services and facilities. The protected classes that we cover in our public accommodations are race, gender, national origin, religion, color, sexual orientation, disability, marital status, age, and gender identity. So, for our commercial non-discrimination, has anybody ever heard about commercial non-discrimination statute? Okay, that's great, because we've only received, since it's been issued, how many, Glendora? Two complaints in reference to our commercial non-discrimination. Now, what we do with this particular article is that we ensure that anybody that's doing business with the state, has a contract with the state, they're not discriminating against vendors, suppliers, subcontractors, things of that nature. So if you know of anybody who feels as though they try to engage business with somebody who's doing business with the state and they've been discriminatory in their practices, you definitely want to give us a call. One of the reasons why we haven't had a lot of phone calls or mails or anything of that in reference to this is because, unfortunately, this particular statute does not provide any sort of financial remedy for a complaint, unfortunately. So the risk of filing a complaint, potentially being blackballed in that industry, is too high for certain individuals to give us a call and express their issues as it responds to this particular jurisdiction. The main functions of our agency: we do intake, investigation, litigation, and education and outreach. So there are multiple ways you can file a complaint with our agency. So, again, a complaint can be filed with our agency by the mail, and I make sure I put an address on there so everybody knows it. So if you feel as though you've been a victim of discrimination, potentially, you can forward a letter into us. You, your attorney, your representative, can forward any piece of mail to us identifying what your issues are, your contact number, the best number to reach you, email. If you have a representative, that representative needs to do the same thing. They also need to identify themselves as representing you in that particular case. You can do it by phone. Our phone number is 410-767-8600. Our office is open between 8 and 4, Monday through Friday. You can feel free to give us a call at any point in time. You can also fax us, right? So if you have an issue, you can also fax that information over to us. Our fax number is 410-333-1841. And you can also do it online and email. Now, online system, I don't want people to get confused and feel like, well, I went online, I did your initial inquiry, right? So they feel like they filed a complaint. That's only an inquiry only. It's not an actual complaint. So if you go online, you complete the preliminary questionnaire, it'll go over to one of our intake officers. They'll give you a call, set up an appointment time for you to come in and actually complete the complaint process. So if you go online, I don't want anybody to feel as though I went online and I filed a complaint. You can't file a complaint online. You can only initiate an inquiry online. So I want to make sure that's known as well. In FY 2016, we received 996 complaints. To break down those complaints over in the graph to my right, as you can see, we had 552 employment cases, 278 transfers, 98 housing cases, and 68 PA cases. As I talked about earlier, we didn't receive any commercial non-discrimination complaints, and we haven't received any in the last 2 or 3 years. One of the stats that stands out to me, again, as we talked about earlier, Maryland has, again, a little less than 6 million people, right? We only received 98 complaints of illegal housing discrimination, right? So one of the things that we've been trying to do in terms of our education and outreach is get out and be more engaged with the community to let people know what their fair housing rights are, right? Because surely we know out of 6 million people, right, in Maryland, there had to be more than 98 cases of illegal discrimination, right? So again, if you have any question about fair housing in terms of, somebody calls you and say, hey, I'm a little concerned, this happened, my landlord is doing this to me, right? How can you help me? Call us, right? We always try to tell people, the old adage, there is no such thing as a dumb question, right? Call us, let us hear about what you have to do, and we'll direct you to the right place. If we can't help you, we'll direct you to the right organization that possibly can give you some assistance. But at least make the phone call. Because we do understand there are a lot of people out there who are being illegally discriminated against, but they don't know what their rights are. They're afraid to call. They don't know who to call, right? Please have them give us a call, okay? I'll make sure I do have some business cards at the end. If anybody wants one, feel free to give them out. It has my office number on there, my cell phone number on there, my email address on there. You can feel free to call me any point in time. I can't say now, if you call me 1 o'clock in the morning, I may not answer, but I'll get back to you, all right? In reference to filing a complaint, for employment, you have 180 days from the last date of the action, right? So you have 180 days, which again is 6 months, right? But again, it's from the last action, right? So it's not from, so if you were terminated in January, right? And let's say you go to file for unemployment, right? And you get your unemployment denial letter sometime in March or April, right? Well, your unemployment letter is not your last date of action. Your actual last date of action was your termination date that was in January. So if you wait 6 months from your unemployment date, then we may not be able to assist you. So again, if you feel as though you've been a victim of discrimination in terms of employment, just clearly understand that you have 6 months, 180 days from the last date of that violation, okay? In housing, it's a little longer. You have 1 year. And for public accommodations, you also have 180 days, 6 months. Any questions so far? Yes, sir.
I'm wondering about transfers and what C&D means.
C&D is our commercial non-discrimination. And our transfers in and transfers out is because what we do is we get cases from our federal partners as well. So we get cases transferred in from ELC, some of the other local jurisdictions as well. So these are cases that were either transferred in from another agency or we transfer them out to another agency. Okay? Any other questions so far? Our commercial non-discrimination, you have up to 4 years to file on behalf of that. And again, they're all from the last date of violation. Our investigator process. Once you come in and our intake officers have the opportunity to kind of sit down and talk to you, right, you provide them with whatever information you have up front. They'll determine at that point in time whether we have enough information to take a charge. If they determine that we have enough information to take a charge, the charge is served on the respondent, and the case is assigned to an investigator. Right? Our investigator will begin the process of collecting evidence. Right? One of the key things in terms of our investigation that we find is that somebody will file a complaint, and again, we understand that you all may believe that I was discriminated against, and they'll come up and they'll have 25 witnesses, right? And of those 25 witnesses, maybe 5 people will be willing to talk to us, right? And of the 5 people that may answer the phone and actually have a conversation with us, they don't always agree with your side of the story, right? So one of the things that we always try to inform people is that when you're giving us witnesses, right, make sure you give us their current contact information, right? Because we'll do our best to find them, but if you give us a phone number that was changed 5 years ago, we can't locate that person, right? We'll do the best thing we can to locate your witness and have a conversation with your witnesses. Make sure that you at least speak to your witnesses before you give us their name and number, right? Because again, the first response will be, well, how'd you get my name and number, right? I didn't tell so-and-so to call me, right? So at least make sure that you at least have, if you believe that witness is going to speak on your behalf, it probably will behoove you to at least have a conversation with that person before we have a conversation. Now, I'm not saying tell them what to say. I'm at least saying the first thing you can do is at least have a conversation letting them know that we are going to reach out to them. You did put them down as a witness, if possible, right, to let them know that we will be contacting them. Now, that won't happen in every scenario. You may say, okay, I know Glendora witnessed an incident, right? You may not have the opportunity to follow up with Glendora. She still could be one of your witnesses, and you may not have the opportunity to reach out to her and contact her. But if at all possible, you want to make sure that you are at least having some level of communication with your witnesses, at least letting them know that there's a possibility that we will be contacting them. So again, the way we collect evidence is you interview witnesses, we gather and analyze documents. Please make sure that you gather all the documentation that you have. Gather up, give us as much information as you have. It's better to have more than not enough, right? Try to organize your documents as best as possible, right? If you have some documents that cover, let's say, a 12-month span, right? We would ask that you put those documents in chronological order so that it's easy for us to kind of analyze them and go right through and see the timeline as you've explained it to us. Site visits. We do a number of different site visits. We go out to the places, whether it's housing or employment, to visit the property or the place of employment to kind of see what's going on, see what the atmosphere is like, talk to some of the employees, right? Talk to some of the other tenants, kind of get a feel for what's actually going on in that particular environment. Tools that we use to expedite investigation, we do fact-finding conferences. How many people have ever been to a fact-finding conference? Nobody. All right. That's good. That's a good thing. I mean, you've never been engaged in the process, right? So the way we do our fact-finding conferences is that we bring in the complainants and the respondents, and they come in. Our fact-finding conferences are conducted by our investigators, right? It's kind of sort of like a semi-administrative hearing, right, where you have an investigator who is able to ask questions of the complainants and the respondents and gather information. The parties are not allowed to ask questions of each other. The only thing they're allowed to do is again, respond to the investigator and supply information directly to the investigator. During that process, we have the opportunity to allow individuals to give us their side of the story while the other party is sitting right there. One of the things that we find out through our fact-finding conferences is that a lot of people just want the opportunity to kind of vent and say how they felt about a particular action. And they want that opportunity to be able to sit in a neutral room with a neutral party and express their side of the story to the respondent at that particular point in time. I would say probably going through our fact-finding conferences, approximately 55% of our cases settled during our fact-finding conferences. We also offer mediation. Has anybody here been through mediation? Any type of mediation, whether it be, okay. Again, our mediation is not conducted by any of our investigators. It's conducted by third parties. They're not affiliated or employed by the Maryland Commission on Civil Rights. We do that to keep a firewall. Any information that's discovered during our mediation is not related to an investigator. Should the case not settle during mediation, that information, if it's written down, is destroyed. We never see it. We never hear about it. And we do this to keep a firewall so that, again, in case if you do decide to go through mediation and the case does not resolve and it has to move forward to investigation, that the investigation is not tainted by any information that was relayed during the mediation. In fiscal year 2016, we closed about 682 complaints. Of those 682 complaints, 340 were settled as no probable cause. We had 155 cases withdrawn with benefits and 88 cases that were settled. A lot of people call and complain and say, well, hey, the majority of the cases closed with no probable cause, right? We do our best to find discrimination if it's there. If it's not, we can't make it appear, right? We do understand there are a lot of issues where we're kind of right there in that gray area between discrimination and it being unfair. Unfortunately, we can't enforce unfair, right? We can only enforce discrimination, right? A legal team tells us all the time, hey, you know, we understand they may not like what happened, but unfortunately, it's just not discrimination, right? So if we're going to move forward, if we're going to move forward in a particular case, we have to ensure that we have a case that we can prove was discriminatory. Yes, sir?
Who makes that final decision for whether to move forward or to close the case?
Our investigators, they complete the investigation. Once they've completed the investigation, they submit the case to their supervisor. The supervisor will review the entire case file. If they concur with the results of the investigation, they'll sign off on the case is mailed out.
So the investigator makes that decision.
The supervisor makes the ultimate final decision. Yeah. If it's no probable cause, and the complainant disagrees with the finding, they have the opportunity to apply for what we call request for reconsideration. Right? They have 15 days from the date of receipt of that written finding to send it to me and request an appeal. So what I do when I get the case file, I look at the entire case file. From start to finish, I look at all interview notes, right? I look at all the documents. So if I concur with what the finding was, of course I'll deny that request for reconsideration. If I feel as though there was some information missing, we need to look at a couple different things, I'll remand the case back to investigation, reopen the case, and we'll do some further investigation. Once we've done the further investigation, I'll look at the case again to ensure how we're gonna issue that case, whether it's gonna remain a no probable cause or potentially be reversed and issue a probable cause finding.
And you would make the final decision the second time around.
In that case, yes. Yes, ma'am.
Could you tell me what some like family status housing cases might look like?
Familial status?
Yeah.
So let's say, for instance, if you know, you're single, that could be a familiar status. If you have kids, that could be a familiar. So let's say, for instance, you go and you want to rent a particular property, right? And the landlord says, well, you have kids, I don't want to rent to you, right? Familiar status. Okay. Any other questions? Yes, ma'am.
Sorry if you're also the organization that oversees Ban the Box.
I'm sorry, say again.
Do you also oversee Ban the Box?
We don't. Any other questions? Currently, we have the highest acceptance rate in the nation of completed cases by HUD EOC. So whether it's an employment or a housing case, normally what we do is once we close our cases go, we send them over to our federal partners for their approval as well. Currently, we have the highest acceptance rates with HUD and EOC in reference to the work that we do on our cases, submitting them for final closure. We also, I'm sorry, the button too fast. Our pending case inventory is also dramatically lower, around 1/3 than the national average. What that does is that allows us to get our cases out in a much faster time frame because our inventory is not as high. Right now, I think if anybody here has dealt with EOC, I think their waiting time right now is somewhere between 1.5 to 2 years with EOC. Our goal at the Maryland Commission on Civil Rights is to get our cases out within 6 months. Our housing cases, our goal is 100 days. Now, we don't always hit that goal, right, but we do our best to hit those goals each and every time. So again, a part of that is the party, right? We gotta make sure that we do get the information from the parties timely so that we can review it timely and make our decision in a timely fashion. And depending on the complexity of the cases, some cases can get closed right away, right? Depending on site visits, if we have to go out, especially, let's say, in our PA cases where we have to do a number of different measurements, site visits, taking photos, to be able to analyze really and get a real feel for the property, sometimes it takes longer. Sometimes we gotta go look at multiple buildings, talk to multiple tenants, right? Everybody's not available at the same time. So some of our cases take a little longer than others. But on average, we do our best to try to get our cases out within 6 months. Our housing cases, again, our goal is to get those out within 100 days. In fiscal year 2017, we secured about $670,000 in monetary relief for the people of Maryland. That number's kind of been going down over the last couple of years. It's been going down for a number of reasons. Not to say that discrimination is easing up, but what we do, I think in fiscal year 2013, we hit a little over $2 million that you'll see by this chart. That's when we first started our fact-finding process. It was in 2013. Everybody was coming in, ready to settle, get the cases out. That happened in 2013. Over time, the amount of money that we've been able to receive for people has, again, continued to decline somewhat, but again, it's not to no fault of ours. We're still doing our job the same way. We're still trying to retrieve any money due to any complaints that we have in our agency. Excuse me. Respondents have been a little less willing to settle. We haven't had as many cases that we had back in 2013, but there are simply just a number of different reasons why that figure has gone down. Our general counsel's office, as I mentioned earlier, one of the benefits that we do have is to have our own internal legal department. So we don't have to worry about calling another attorney saying, hey, I need you to take a look at this, waiting for them to get back to us. I have the opportunity to go to our legal department day in and day out. And trust me, I'm in their offices day in and day out, right? I know they get tired of seeing me. They hear me before I even get to the office. They're up, here you come, right? But that's one of the benefits that we do have, that we have a great legal team in-house. We can go to them, ask them any questions, and get things addressed much faster than most people can. The Office of our General Counsel represents us in all legal matters before the Office of Administrative Hearing, state, federal trial, and appellate courts. One of the things I also need to make everybody aware of is that our legal team does not represent complainants, right? They represent the law, right? So should we move forward in a complaint of discrimination, they would simply be representing the state of Maryland as we're enforcing Title 20. They're not actually representing the complainant. So complainants still have the opportunity and the right if they want to seek their own personal counsel as well. But our legal team only represents the law. They provide us legal counsel. They provide training, counsel, and legal advice for our investigators, and they provide technical assistance on best practices under Title 20 and 19 to the public. So you may see Glendora out at a number of different events talking about the services that we provide as well. She does a lot of that across Maryland as well. And they are responsible for our legislative agenda. Did anybody here go to Annapolis, testify a lot? A little bit? Little bit. Well, I'm sure you'll see Glendora, because she's there every day during session, so. Now what I'm going to do is I'm going to pass it over to our education and outreach specialist to talk about, from education and outreach standpoint, some of the things that we're currently doing and what we're working on in the future. Mr. Keith Murphy.
Thank you very much. All right. This will be real quick, because this probably is this has been one of the jobs that I've loved doing my entire life. I've had lots of training jobs, and I really love this job. But what MCCR does is, over the years, we've grown. If it weren't for our legal department, if it weren't for our investigators, it's very difficult to cover all the events, education requests across the state with 2 people. Very, very difficult. And so I just want to go over some of the things that we provide. Our trainings are free to people in the state of Maryland, whether it's a business, a company, a faith community, whatever, you know, if you want us to come out. So this is one of those. This is that agency overview. So we come in and talk about what we do. Usually a part of most of our trainings, we have a tiny abbreviated version of this. It's kind of like having your commercial. You know, and with everything you're part of, you got to have a commercial. So to let people know that we exist. Because of name changes, sometimes people get confused and go like, you don't exist anymore, or we tried and we couldn't find you. So we do employment discrimination and prevention training, public accommodation, fair housing discrimination prevention. I'll talk a little bit about a special program that we do. Commercial non-discrimination, sexual harassment prevention, investigative techniques for investigators, retaliation, conflict resolution strategies and responses, dimensions of diversity, gender identity, sexual orientation. Safe Spaces training is a program we do in conjunction with Salisbury State University, and it's creating workspaces that are safe for persons who deal with sexual orientation as well as gender identity. So we work in conjunction with them to provide training to business places on how to make the workplace more accepting, how to deal with issues that may arise. We do religious or spirituality awareness and accommodations law. This is one of our newest, especially as, you know, we know how diverse our country is, but we just haven't talked about it. And so people come to work and they ask for an accommodation around their religious belief system, and someone says, no, we can't do that. They just shut you down. Glendora can tell you story after story, but people's like, and we say, you know, you know, what else can we do? So we also want people aware of the fact that the people that surround us are not always like us. And our belief systems is a part of who we are, and it's a wonderful concept to be able to respect that. It's like, just because I don't believe the way you do doesn't mean I can't learn something from it. You know, it can't inform me about my own spirituality. Another one that we've kind of expanded, disability issues awareness in the law, especially for workplaces, when people ask accommodations in disability. You know, I've done trainings before where people ask a question, like, why are you asking that? Wouldn't you just do that because you want your workers to be happy, right? But that's one of the things. We want to make sure people are aware of that. There's so much in the area of disability that we don't know about individually. There's so much information out there. Our newest program, and I'll talk about another one, but our newest is the Maryland Equity and Inclusion Leadership Program. We're kicking off in March. We're having a class of 35 persons who are going through our program. They'll meet monthly. They will have a project that they will take back to their workplaces on diversity or inclusion. So they'll be listening to speakers across a broad spectrum, speakers from across the United States, talking about diversity and equity and prejudice reduction and all of those things, and how do we implement that in the workplace? How do we make our workplaces safe places for people? You know, not just like, let's just follow the letter of the law, and we're a legal agency, right? But we also want to make sure that people feel like when I go to work, this is not a place that I feel attacked. And it may not be, it may not be about being illegal discrimination, but how am I treated at work? And how can I make that word acceptance for people? So that is one of our newest. We'll do a class every year. It'll start in March. So toward the end of this year, we'll send out what calls for people to apply. And so that is something that you'll see if you follow us on our Twitter accounts, if you follow us through any of our accounts out there, and sign up if you would like. I put the paper out there. If you want to sign up, you'll get that. You'll know when it comes out. The other one that I want to share with real quick is a program we do. Cleveland was talking about housing. So one of the outreach events things we do is a book project with children. It's called the Fair Housing 5 Project. And this is a book that was written through the New Orleans Fair Housing Consortium. And it's a children's book written. You know, I have 20 copies that if you're interested in having one, please see me afterwards. I'll make sure you get it. And it tells a story of a mother and a daughter trying to find a place to live, and the landlord across the street won't rent to them because there's a child involved. And then other people are not allowed there, like a person with a dog because he had a disability. Or why won't you let that person live there? Well, evidently he doesn't like women. So there's a whole, so what we do is we read the book, we discuss what went on, and we usually do an art project with it. So we either have them, they may do a project where they create their perfect neighborhood. What would their neighborhood look like? Or what would your perfect house look like? And talk about the fact that children are the one that feel the impact of unfair housing. That they know when they're not accepted somewhere or they're treated differently. We all did. We knew when we didn't fit, right? And so for children to be able to discuss it, the fact is they know when they don't feel accepted somewhere. So the word that I would like for you to get out is if you have schools, libraries, any kind of organization like for us to come out, we can work with, training persons to do this program, or we can come out and work with you doing the program. It's usually like a 2-day session, like not a whole day, but 2 sessions, and working with the children. So that's one of ours that I think is, that we've worked well. We've done programs in Hartford County, Carroll County, Baltimore County. So we've done several outspread, and we've done some in Baltimore City as well. And so that's, as you can see, it's just a little bit. So my job is really easy. I only have to work 2 hours a day because, this is just so little. But there's so much out there and so much more we could do. And that's the thing, is there's always something else we can do. But we want to let you know that this is available to you, this is available to your organizations as well, and to your families. So, this I was just going to give you. This is just our graphic for the Maryland Equity and Inclusion Leadership Program. It's helping people to understand the equity and inclusion issues that are facing people in the workplace. How do you develop it in your organization to make sure that people feel included? Thank you. So I'll have these with me, so y'all just see me afterwards.
So one of the things that we recognize in today's climate, right, that there are a lot of issues, right? But we can only help address those issues if we know about those issues, right? If you recall when I first started talking this evening, and I asked how many people knew about the Maryland Commission, unfortunately, less than 50% of you all even knew that we existed, right? So one of the things that I ask of you, that if you know of anybody, right, who has any issues, whether it be employment, housing, public accommodations, that you please give them our information, right? We want to know what the issues are so that we can figure out if we can help them address and resolve those issues. We can only help if we know, right? There are a lot of people out there who think that we just somehow magically know, right, everything that's happening. Unfortunately, we don't. And again, we can only address those issues that we know. When we talk about employment, whether it be promotion, whether it be hiring, whether it be discipline, right? We want to know what those issues are. Give us a call, talk to us, right? Let us tell you if we can help you or not. Don't just go off and figure, oh, nobody can help me, I'm kind of stuck, right? Because nobody is stuck. We don't want anybody to feel as though that they're stuck. We are here to help. We're willing to help. We have a number of employees who are also willing and committed to helping address these issues. When we talk about employment, what do people probably think is the #1 protected class in employment that are discriminated against? Based off of what? Could it be disability, religion, color, sex,
Gender
gender?
or race?
Anybody else? You said gender first, so we're gonna go with gender. Anybody else? So, in employment is race, right? You know, race is still an issue. It's an issue in Maryland. It's an issue for the entire country, right? So what we do see is race is still our #1 issue when it comes to employment and how people are being treated differently because of their race. And again, whether it's promotion, hiring, discipline, right? We're trying to, again, help resolve those issues. The only way we can help resolve those issues are if we know about those issues. And housing, right? Whether it be failure to reasonably accommodate, failure to rent, right? What do we think is probably the #1 protected class that's affected by housing discrimination? I'm sorry? Race? Maybe. Anybody else? I'm sorry? There she go again. Exactly. Disability, right? The #2 category in employment and housing. What do we think that is? Maybe. Anybody else?
Gender?
Gender? Anybody else?
Gender identity?
Gender identity? That's rising, but it's not #2. Age? Retaliation, right? It's a #2 category in both employment and housing, right? Which also causes fear in individuals, right? Because if you see something and you speak out and then you're retaliated against, right? Unfortunately, you're less likely to speak out again, right? So again, there's a large population out there that knows what's going on, but they're in fear, right? In fear that if I speak out, I'll lose my job, right? My landlord might kick me out, right? And these are real issues for these people, right? So not only are they able to see discrimination happen to somebody else, right? Now they're living in fear because they saw it, right? So they're fearful that the individuals in charge have now, they know who saw it, they know who's aware of it. So any given day, they're like, you kind of walking on eggshells, right? So retaliation is the #2 category in employment and housing. So one of the things that we do want to reassure people is that if you have ever spoken out or participated in any type of discriminatory issue, we're here to protect you, right? If somebody is retaliating against you, you can contact us, we can talk about it, file a charge on your behalf, and investigate, determine what happened, right? So that's also key to make individuals aware that we are here in case you have participated in a protected activity. Whether that's been, you were a witness, you testified on behalf of somebody else in another discrimination suit, if you ever filed one before, right? We are here to help you. We don't want people to feel like they're stuck, they can't say anything because of what might happen to them, right? Our failure to speak, right, gives acceptance to the behavior that's going on. So we do want to make sure that we continue to speak out when we see issues, and we're helping not just ourselves, but we're helping, you know, our fellow citizens out as well. It's going to take all of us to fix this issue, right? It's not going to be fixed by one race. It's not going to be fixed by one gender, right? It is really going to take a concerted effort from all of us to fix these issues that we have here.
One question, you said if you bring a case on behalf of Maryland, the state, the complaint, the person filing the complaint still has the right to pursue their own case in court. Is that what you're saying?
They do. I was saying, let's say for instance, you file a complaint with us, right? We rule probable cause, right? And we go to court on that particular issue. Our legal team is representing Title 20, right? They're representing the law, not you individually. If you decide that you want to have personal representation, you have the right to also have personal representation as well.
So if the commission wins, I guess, what is it, like what is the penalty as opposed to when the private, litigant prevails,
In terms of the administrative process, where there's 3 parties in that. There's the state of Maryland, there's the complainant, there's respondent, the employer or the housing provider. look at it as similar to a criminal prosecution, where the state's attorney represents the state and not the victim. So we enforce on behalf of the people of the state of Maryland the complaint. We present the complaint, we litigate. The complaining party does have a right to have an attorney. Now, there's also an employment and housing option where if you choose not to go through the process of an administrative hearing, you can elect to have the case go to court for a jury trial. Or if you don't want the commission to proceed with your case, you can elect to get your own attorney and file your own lawsuit on your own and with your attorney after 180 days. You have that option to elect out and get your own attorney and file your own private action in circuit court.
So within that 180 days, you can't file your own private.
It's technically called administrative exhaustion. You have to give the agency an opportunity to do the investigation and to try to resolve the case.
So do you have to file with the agency, or do you have to just
You have to
wait?
file.
You do have to
You have to
file.
file, because if you jump into court without following the agency, your case will be dismissed.
But after 180 days, regardless of what happens at the agency level, you can file your own.
Right, after 180 days, you want to go to, you want to go private right of action, then you notify both parties that that's what you're likely to do, and you're following your action. And we would, once we get notice that you are actually filed, get a copy of your complaint, then we stop
Oh, really?
processing your complaint.
Okay. And that's the thing, can you consolidate your federal and the state? Because I know like the federal equivalent of a lot of these
You have to
laws.
pick your form. You got to choose whether you want to go to federal court or whether you want to go to state court. One adding of this private right action is to give people access to state courts, because the federal courts weren't so friendly to employment cases because of the makeup of the court. And plus, it's more accessible statewide because there are circuit courts in every county, whereas federal court, there's only 2 federal courts, one in Greenbelt and one in Baltimore. So if you live in Garrett County or you live on Eastern Shore, your ability to access the court is limited. So that was one of the reason of adding to our law that option of being able to go to the state.
So people don't give up their personal right to file or whatever based on filing with the agency.
No, you're just establishing jurisdiction. You follow the rules so that you can get in.
And that's one of the reasons in terms of the 180 days, why we set our goal at 180 days, so that we do our best to get our cases out before then, so you at least know where you stand at if you so choose to move forward with the case if it's not your fate. Any other questions? Yes, ma'am.
Hi, I know I just came in and I'm a senior advocate, so I represent, different seniors. I have a business for seniors as well. So, seniors had, I'm so sorry. Seniors had a lot of, issues as far as housing go, especially like with the state and the city, their landlords, things like that. I mean, seniors are being put in housing situations where, when they were first put in them, they were specifically for seniors only. And then later on, they, put different people in the senior facilities that are detrimental to seniors. It's a House bill, I can't even think of the name of it, I could pull it up now, that was voted against for seniors where they would not allow felons to be put in facilities for seniors. Because, and then seniors are afraid to speak up because of the people that are living around them that they feel threatened by, that they moved away from, into senior facilities that were specifically for seniors that are no longer for seniors. I don't know if anybody has seniors in facilities like that, in housing facilities where they're afraid to come out of their doors because of these kinds of issues. People are, accosting them in the hallways, in the elevators and things like that. So for this kind of thing and across the board, what can I come to you with for help for my seniors?
That is a real interesting issue for Baltimore City, because under the Fair Housing Law and under the federal law, there is, when we talk about familiar status, it's for families with children, which include a person who's single, who has a child, a person who's adopting, etc. Then there was an exception made to the families with children to establish senior housing of 60 and older, and then 55 and older. And with the 60 and older, you could have a building or housing for seniors where only people that age can live in the building. That you have to, in order to qualify to live in the building, you have to be 60 or older. And then 55 and older, that was a compromise in allowing people who were couples where if one of the spouses were younger, they could still live in the community or the building as long as one of them was 55 or older. Well, apparently there was a lawsuit filed in Baltimore City. Part of, I don't know whether it was the agreement or the ruling, Baltimore City agreed to provide additional housing. Well, what they decided to use for the additional, that was the senior facilities. And what you have is younger persons who have disabilities.
And felonies.
Right, and their friends who come to see them.
And their friends who come to see them.
And now
who
you
intimidate
have
the seniors.
these buildings, many of these senior-only buildings now being compromised, and you have the situations that you're speaking about. One of the things is that, there needs to be, you need to go to the housing authority in Baltimore City to address that problem, because they chose the option of utilizing senior housing as a means to address the outcome of this lawsuit. As opposed to, affordable, over umbrella, affordable housing across the state is an issue. But that was the result of responding to that lawsuit, in which their solution, or quick solution, was to open up and use senior housing as a place for disabilities. Now, quiet as a kept, there's some senior buildings where they did it and then they reversed themselves and they removed them back to senior only, and they removed the younger, particularly the ones that had some difficulties. But I think that's, it's a local issue where you're gonna have to go to the city and to bring that issue up in terms of identifying those places where there's challenges, because that's how that came about, that's how that happened.
And do you have any idea how that was overturned? I mean, was it just a case of people complaining or going to speak up or going there?
I think the ACLU brought a lawsuit against the city.
Oh, that's.
I think that's what happened, because persons with disabilities were having, and they're advocates, so you're gonna have to do the same thing they did, is that they said that, there was minimal, if no, housing for persons with disabilities. Well, they knew that, and this is why, another reason why the senior buildings were easy to pick, because they knew that senior buildings would be more accessible because of the age, so they have accessible bathrooms, accessible, so this was a quick fix, which turned into a bad situation for people who are seniors, who are now being held captive in their apartments.
Correct.
Instead of, right. That's how that came about.
Thank you so much for that.
Yes, ma'am.
I was just wondering, so in turn, it's basically like this wouldn't be a case for you guys because the law is being followed. It's a matter of following civil action, advocating for them so the law can be changed to still accommodate
Right,
seniors.
because what they did, they just changed the building from being a senior-only building,
So it would be nothing.
which they can do,
Right.
and that's what they did. The law says that you can have a seniors-only building, but it doesn't say you have to have a senior-only.
Yes, ma'am.
I wonder what's the difference between the Maryland Commission on Civil Rights and the Baltimore City Office of Civil Rights and Wage Enforcement? When do we go to Baltimore City? When do we go to Maryland? what's the differences in the kind of cases you all see?
So we're very similar in some areas, and some areas we're not, right? So we're the state agency, they're the local agency, right? So there is some overlap, right? There are also some protected classes that Baltimore City covers that we don't, right? So I would say that if you have an issue in Baltimore City, right, not that we don't want it, right, and not that we don't want to hear about it, I would say first, research the Baltimore City Office of Wage Enforcement and see if they cover it. You can contact them, but you can also contact us. So we work in partnership. So earlier, like on a couple slides in the beginning, we talked about those transfers in and transfers out, right? So there are some cases that people will come to us to file that Baltimore City can handle, and we'll transfer to the Baltimore City office and let them investigate that. But if it's an area that happened in Baltimore City, but the Baltimore City office doesn't cover it, you're still covered by us if it's under our jurisdiction. So it kind of gives you an option.
Do you all also handle like harassment claims?
We do.
So like I have a family member who has a substance issue and may have mental health issues, and she feels like the police are monitoring her phone calls and watching her outside of her house. Would you take her a case or?
Yeah, that's going to be a difficult one.
Right.
Only in terms of, I would say in reference to that, I would probably refer her to Baltimore City, only because, again, they have more authority over kind of like the police department from the civilian review board standpoint. So I would have her follow up with the Baltimore City Office of Wage Enforcement first and see what actions they can help her with. It's going to be difficult for us to take it. I think you were going to say something earlier, work. No problem. Got you and then you.
When you're investigating a case of discrimination, let's say it's employment discrimination based on either race or gender, what things do you look for to confirm that it's actually a clear case of discrimination?
There are a number of things that we look at. I mean, we look at, witnesses, right? Did anybody witness the particular action or what have you, right? We look at documentation. So let's say it was a disciplinary issue, right? And you feel as though you're being treated differently because of, let's take gender, right? So you're female, and you believe that you're being disciplined for issues because you're female and males aren't being disciplined for the same issue. So we would look at, we would talk to other female employees such as yourself to see if they're encountering the same issues. We talk to male employees as well. We also would take a look at the disciplinary history for employees in similar positions as you would be, and kind of see what that disciplinary history is. So there's a number of different things. We talk to management, a number of different things. So there's not one clear-cut answer, right? It's always case by case. So it really all depends on the facts of the case. Sometimes some cases are more evident than others, and some aren't.
And the other piece is that in order to build a case, we have certain theories under the law that we have to prove that case. So like he talked about, you feel you're being treated different. We call it differential treatment or disparate treatment. And we want to find a comparative, someone that is similarly situated as you are, but they are treated differently. You were disciplined, say both of you got in a fight, you were fired, and that person was suspended 1 day. That's disparity, that's differential treatment for the same act. There are other theories we look for direct evidence. Somebody made a statement that we're not going to hire any pregnant women here. That's direct evidence, the smoking gun, the direct evidence. And then there's the other theory would be disparate impact, that there's a neutral policy that the employer has, but it affects a particular group, a protected class of folks. And that's how we gather our evidence, which is why sometimes when we look at our evidence, what you say may determine, yes, it was unfair what happened to you, but we can't prove it because we can't meet the theory that the law requires us to show in order to establish that there's discrimination and that there's discriminatory intent on the part of the landlord or the employer, what have you.
Yeah.
So I just had 2 questions. One question, just as a clarifier. So is the Maryland Commission on Civil Rights kind of the catch-all for those 4 areas? Like, is it the case a lot of times that, you know, if there's any cases of discrimination or things like that, does it typically come through your office, or is there? Because I've heard there's a bunch of different offices that allegedly kind of handle these kinds of issues. But in most cases, does it kind of end up in your lap? Or
No, it all depends. I mean, we receive and we send out, right? So, I mean, it used to be, I want to say, maybe 3 years ago, right, that 3 or 4 years ago, that the majority of the cases were funneled through our agency, and we transfer a lot out. Now, the local agencies are now more aggressive and more active in terms of actually taking those complaints themselves. So it all depends on where the individual wants to file. There are some people that feel more comfortable filing with the state agency versus the city agency.
Right.
So it all depends. And again, it still goes back to jurisdiction, right? There are some issues that we can address that the locals can, and vice versa.
Okay.
You really have 3 places you can file, and it's your choice. You can file locally if you're in a jurisdiction that there's a local enforcement agency, because there are a lot of parts of the state that don't have a local enforcement agency. You can file with us, a state agency, or you can file with EEOC, or you can file with HUD.
That's federal. EOC is
Federal,
Right.
right.
Yeah.
You can file with a federal equal employment opportunity, or you can file in housing. You can file with HUD, the Federal Housing and Urban Development. The difference there, one thing with if you file with HUD, it still will end up with us.
Right.
Still coming back.
It'll still come back to us. Now, EEOC, if you file with them, they will keep the case unless there's a request for transfer for some reason or the other.
Now, we don't tell people not to file with EOC, but exactly what Glendora was referring to, unlike with HUD, where if you file with HUD, because we're a fair housing assistance partner, those cases come right back to us. Now, with EOC, you go into a queue, right? Now, the investigator who picks up your case could be in Cleveland, right?
Yeah.
So we always try to make sure that people kind of understand that, because EOC does have so many cases, and they only have a limited amount of investigators that are actually here in Baltimore, that if you file with EOC, there's a good chance that your investigator will be out of state somewhere. So we try to, again, make sure that people do understand that. And there's also the wait time with EOC, which is about 1.5 to 2 years before they even get started on your case. So again, we don't tell people not to file with EOC. We just want to make sure that people are informed so they can make the best decision with whom to file with.
Is that journalism?
I'm sorry, I just had a second follow-up real quick. And this is just more, I don't know if you can answer this, because it's kind of based on what's kind of happening in the political climate around the country, because people are talking about Donald Trump and so his impact and his influence on a lot of these different structures or whatever. And so, because people talk to us a lot about, we're afraid that because of Donald Trump's, ascendancy into the presidency, that, people who have racist views or like employed in institutions, like in housing institutions, employment or employers or what have you, that they could use kind of this new vigor they have as a result of the administration to enact a lot of prejudice and discrimination. So in cases like that, because we do get a lot of those complaints, because we're not an investigatory agency of any sort, but as an advocacy organization, we want to make sure we're pointing people to the right folks. And I guess what's the advice for folks like us when we receive these kinds of complaints, about these particular things, the 4 areas you mentioned? Are you saying that it's usually best to defer them to you, or to start with the local agency first?
You can always give us a call, right? You can give us a call, we can see and then we can figure out if it's better for them to go to a local agency, or if that's something that we want to handle ourselves, right? So one of the things we tell everybody, regardless of who's the president, right? The laws on discrimination have not changed, right? So we're still enforcing the same laws that we were enforcing before Donald Trump got elected.
Exactly.
So that doesn't change. Now, we understand that there are certain people who are now emboldened by the new administration, right? And they're taking certain actions, and that's fine, right? But at the same time, we want everybody to understand, and we're also taking action, right? So if you violated the law, we're going to address it regardless of who's president.
Exactly.
So just let them know that as well.
So the other thing is that in terms of federal and state law, is that there are times where even if the Supreme Court makes an adverse decision in an employment case, where they make a decision that has a negative impact in discrimination, if they're reviewing Title VII, they're not reviewing state law. So The judges in the state can decide not to follow that decision. And we do argue that, Your Honor, the state of Maryland enforces Title 20, the Supreme Court ruled on Title 7. We encourage you to go this way instead of following them. And there are times where the state courts may divert to a different opinion on the same issue because they're interpreting Maryland law and not federal law.
Okay, thank you.
Young man in the gray shirt, yeah.
Yeah, I was wondering, in terms of like employment discrimination, if like witness testimony is like enough often, because I'm sure in these cases you have like a lot of like he said, she said.
I mean, we do, and that's when we have to assess credibility. There are some cases that we have, all we have is witness testimony, right? And again, that's also part of our outreach when we're talking to individuals such as yourself, to tell people, look, if you feel like something is happening, right, begin to document what's happening now, right? Because normally what happens, unfortunately, is a lot of times when people realize what has happened, right, all the documentation is in the power of who? The respondent, right? So you get locked out of computers, right? You can't get in, right? If you've been terminated now, you don't have access to anything, right? So if you haven't gathered your documentation, well, the respondent controls all of that, right? So we'll still go out and request documentation, but the documentation is coming from the respondent, right? So we try to inform people to, again, get educated, right? And if you feel like something wrong is happening, document what's going on, right? Document it in real time, save whatever documents you have,
Keep a diary.
create yourself a file, a diary, right? So that you have something at least to present to us. If not, again, there are times when we only have witness testimony to go off of, and that's what we have. But we try to, again, to tell people, if you feel like something is a little fishy, start documenting, create a diary. But first, give us a call, right? So we can kind of, again, assist you and kind of tell you how to move forward.
Especially if you're being harassed, harassment cases. One of my first sexual harassment cases was, it was just their testimony against what the employer about what's happening. But what they did was that they kept the diary. So, people's, your memory is not going to be exact about what happened on what day. But because they kept a diary, when they testified, I could refer them back to their diary where they could specifically say, yes, on this day, he did this, and on that day, they did that. That's impressive to a trier of fact, to the judge, to a jury, to hear specifics about what's happening. So that even reinforces the credibility of the person who's testifying about what took place and what happened to them.
I was going to say, to add to that I think it's also important to reiterate what Cleveland said, to go ahead and file, because you shouldn't always look at your case as like, do I have enough evidence to file? Because first, every employer out there isn't the worst employer, and I know that's how it sounds sometimes, but even just receiving a charge sometimes puts the employer or the provider on notice, like, okay, so something is wrong here, and they want to conciliate, they want to work it out, they want to talk to our agency about it, they want to talk to you about it, they want to mediate, they want to step in, and sometimes they don't even, they're like, okay, you can investigate, but at the same time, we'd be willing to talk to this person about it. Do you see what I'm saying? So you don't necessarily have to file the charge thinking, well, I have to have a slam dunk, or else there's no point in me filing a charge, right? We may not even get to that point.
And to be honest, probably say of all cases we receive, we probably get maybe 5 or 10% that are like slam dunks, right? The most of our cases, we gotta work.
Yeah.
We gotta get evidence. We gotta talk to witnesses. We gotta do site visits, right? So again, people kind of get this notion because you see on TV, right, that there's an employee that just paid $250 million, right, in a discrimination lawsuit, right? That not every case is a slam dunk, right? And those cases normally take a lot of time, right, before they get to that point. So we want people to understand and be realistic when you do have an issue, right? That when you come in, you're saying, all right, I think the number is like 1.5, right? We ask people, what are you looking for? 1.5. It's something about that 0.5, right? But, they want $1.5 million. So we ask people to be realistic, be able to articulate actually what happened to you, right? If you're saying that you had some sort of like emotional distress, right? We hear that a lot. People saying, well, I was emotionally distressed, right? Well, how? you gotta be able to explain that, right? You gotta be able to articulate whether, you know, it was something that happened between you and your spouse, your attitude started changing, your spouse can attest to that, right? You went to go see a doctor, you're now on medication, all those types of things. Just saying you had emotional distress really isn't enough. So again, when you talk about, when you come to our agency and you're having issues, we want people to also understand, think about what are your real damages, what actually happened to you, right? Being able to justify that and prove that is very important.
One last question. I mean, you have laws on the federal and the state and the local level. How do you know, if you go to say, you know, the commission, how do you enforce your rights that might have been violated on the local level as well as the federal rights? You know what I'm saying?
So normally what happens is all of us are substantially equivalent, right? All of our laws overlap at some point, right? So again, as long as our laws overlap, right? Again, we only enforce state law. So it could have been a city issue, but it's also a state issue, right? Because we cover it as well. So that's how we're able to enforce it. But we're not enforcing the city law. We're not enforcing the federal law. We're only enforcing Title 20. So as long as it's in Title 20 and it's covered, we enforce it. So you could have it in city law, state law, and federal law, right? But whomever you go to enforce it is only going to enforce it at their level. So we're not, again, when we go to court, we're not going to court on behalf of EOC, right? We're not going to court on behalf of Baltimore City. We're going to court on behalf of the state and the state only.
So you have to choose which law.
You have to
You
choose,
do.
you don't get a do-over.
Yep.
So you have to pick your form as to where you want it to be tried. If you lose, you don't get to go to the
Yeah,
next
that's
one and start all over again.
And you can't, for instance, you can't go to the city on Monday, come to the state on Tuesday, and then go to the federal government on Wednesday and try to file 3 separate charges for the same thing. And trust me, people do it,
They do.
right?
And
But
we
it-
talk to each other.
Yeah, we
so
talk
know.
to each other.
There's a database.
Yes, ma'am.
Another thing that I do, human resources and staffing. So with that being said, do you take on unemployment cases?
In terms of what?
In
You say
terms of,
unemployment.
like people who have been denied unemployment and they feel like they've been denied wrongly.
No.
No. There's the unemployment law that's separate from us, that covers that. And so that has to be, you know, we don't enforce the unemployment law. The one thing that, and one of the things to know is that employers will say, well, that issue was brought up before the Unemployment Commission, they claim discrimination there, and they rule X, Y, Z. That means nothing to us because it was analyzed under the unemployment law. We will still take your complaint, and you will still have the right to have your case investigated for that discrimination complaint because it wasn't under our law that the discriminatory allegation was looked at.
So like if, because one of the things they always say is Maryland is an at-will state.
Yes, it is.
It is.
You know what I mean?
It
So,
is.
Private industry.
right, private industry, so the person, the employee has a will to leave as well as the employer has the right to fire them. But in most cases, when the employee leaves, and most people leave because of, well, anyway, if they leave under at-will too, but then unemployment says that they didn't have any right to do that, for several reasons, even though they may cite them, in that whole thing, so.
You know, if you quit, you may get penalized. If you're fired, you may get penalized as well. You know, because in terms of the terminology, in case those who don't understand, at will, is that the employer can fire you for, and not even give you a reason.
Correct.
You know. And a lot of people will come to us and say, well, they didn't give me a reason why they fired me. And they don't have to give a reason.
Right, but
And-
with the employees, if they leave because of whatever, if they're, being treated hostile, in a hostile work environment, or they're not given the tools in which to do their jobs, which are valid reasons, more than often they still get denied because then the employer comes and has this whole laundry list of stuff that
Because the employer's
usually
gonna say,
is
they're
not
paying in the unemployment pool, and they're saying you quit on me. And I'm not paying you unemployment because you quit on me. And so that becomes an issue, and the law, under employment law, there's some penalties for doing that. And I I know you're talking about in terms of trying to get representation. I mean, there may be representation available in the legal aid or the Public Justice Center. They provide attorneys for civil actions, and there's volunteer lawyers with the Maryland State Bar Association that represent people in those kinds of issues and those kinds of topics.
But what
But
also,
a piece of what you were saying also sounded like constructive discharge to me, though. That if the person was, if you leave a job under duress because you feel that based on your protected class, or because you engaged in protected activity and you felt that the environment became so hostile you could not continue further, that would be considered constructive discharge, and you can in fact file a charge on that basis. That does not mean that our agency could then put any pressure on the Department of Labor Licensing and Regulation to provide you with unemployment benefits, but once you file the charge, there's potential for conciliation.
And what's it called? Constructive?
Constructive
Constructive
discharge.
discharge,
And one
under
such,
any protected class.
under any protected class, and one such option that we do with what we call predetermination settlement agreements is sometimes the employer will agree not to contest unemployment benefits. They'll say, okay, we'll allow this person to collect unemployment. That's a settlement option, and it's not a guarantee. But and we can't do anything with the Department of Labor
Right,
Licensing and Regulation, but the employer may agree to
Agree
allow
not
the
to.
And see, I see it so much on both sides, like I'm in the meetings, and I know that the employers are lying. You know what I mean? I know it, but I can't say anything. And, and then the employee, is just, like they can't believe what's going on because they know it didn't happen, and then the employer has their lawyers there and all that, and it's just really unfair.
and another thing that we see, we always tell people is, just because you get unemployment benefits does not mean you were discriminated against, right? Because we get a lot of people that come in, they'll file a complaint, and they'll say, well, all right, here you go, right? Here's my letter saying that I was discriminated against, right? And it's the unemployment letter, right, acknowledging that now that they are receiving unemployment. And again, the same thing that Glendora talked about, is that's a different process.
Right.
So just because you are awarded unemployment benefits does not mean that you were necessarily discriminated against. You may have been, but that letter does not grant you any sort of smoking gun or approval that you have been discriminated against. Yes, ma'am.
I had a problem with unemployment, and I had great reason to leave, but the rule was, if you didn't leave for this reason, if you left for anything other than this reason, we don't have to give you the benefits.
Right.
So while that could have been good cause, it's like, well, these are the causes that
We
we say are
accept,
good causes, and we are giving you this money. So while, hey, I feel you, but guess what? These are our rules, and while your job might not be disagreeing with us, these are our rules. So.
And as Kara was saying, again, not contesting your unemployment from the respondent standpoint still doesn't guarantee that unemployment is going to grant you that pay. And we have absolutely no control over that. We tell people, although we are a state agency, right, we don't control other state agencies.
And part of your relief may be if we either settlement or we win the case, is getting your back pay and your lost wages as a result of the Discriminatory Act. The idea is to make you whole. Equitable relief is to put you back in a position you would have been but for the Discriminatory Act.
Yes, ma'am.
But it would be better to be smart about it and not quit, but to file a complaint first, right?
It all depends. It all depends on your situation. I mean, there are some people who are in very severe situations, especially from a health standpoint, where you continuing to stay there could continue to exacerbate your condition and make it worse for you. So it really all depends on the case.
Sexual harassment cases, you're being harassed and you see no way out and the employer is not doing anything about it or taking it seriously. People feel like there's no other way other than to remove themselves from the situation before a crime is committed.
But to file a complaint.
To be strategic, the best thing to do is to start documenting what's happening early.
What's happening
Contact
early.
us early,
Yes.
right? Engage in conversation with us so we can help you along the way.
Right.
That's the
Right.
best way to do it.
Exactly.
Yes, sir.
I was just curious, we know in school districts like Baltimore City that black boys and girls are disproportionately disciplined for the same thing that white peers would be. I don't think that falls under what y'all deal with, but I'm curious if somebody were to bring a lawsuit against, say, Baltimore County or Baltimore City and review those disciplinary records that would show that there is a clear discrimination or pattern of discrimination based on race in that case, who might that be, or?
Department of Education.
Okay.
Because that's going to be, yeah, because that's not going to be under our purview because of education, and unfortunately, we don't have any jurisdiction over education.
Or exteriorly, you go to the outside organizations like the Public Justice Center, like the ACLUs, to bring a class suit against the system, where they would do an extensive investigation, because you're gonna be doing a lot of statistical analysis and so forth in terms of determining, being able to show the data, about the disciplinary action. I mean, there's a big deal going on in Howard County about that very issue. And it's revisited, because I remember maybe 20 years ago, we did a commission investigation, because there was that same issue about discipline in Howard County schools based on race. And they put a ombudsman person into the office. I don't know if they let that person go, but that problem is rearing its head again. It seems that we never learn. We keep going back, making the same mistakes and doing the same thing. So usually, sometimes people have to have the stick. They have to, somebody that, be caught up in a class action where they're going to be having to be sued for the discriminatory treatment that's happening in the schools. And those are usually the organizations that bring those kinds of big class type actions. Suits the NAACP Legal Defense Fund has brought actions around the country on that topic as well, in other school districts around the country.
Do you know who's bringing the one in Howard County right now, by chance?
I know there is a dispute and a discussion going on. The parents themselves are rising up and are going to the school board and going to the superintendent and saying we're sick of it. So I don't know if they reached a point where they've gotten counsel and are proceeding down the line of litigation, but I know that is an issue that has reached the boiling point.
Thank you.
I'm just gonna have a couple more questions and try to wrap this next bit.
Yep.
Oh, is the Maryland Commission involved in protecting groups of people who have been affected by the executive order that came from the White House, like on the basis of religion or nationality now?
I mean, religion is a protected basis, so, national origin is protected basis. So regardless of the ban, we protect those individuals anyway.
Someone files a complaint, we're going to investigate it. It's a federal ban, and it's a federal executive order that addresses certain issues federally. One of the things that different groups have talked about in terms of, because of the anticipation of the climate change that was going to occur, in that, what can people do? You need to look at things that are happening on the national level, but there's still a different environment at your local. All politics is local. So where it really impacts you, where things really impact most people in their day-to-day housing, employment, it's at your state and local level. And you have to hold those people accountable, right? One of the things they say, people come out and vote in droves on national elections, but they don't come out for state and local. Well, those are the people that are going to have the most impact on what happens, the policy decisions, this whole thing dealing with the police and the consent decree. That's local. That's right here. And so the attention and the protections, because many times when you look historically at civil rights laws, the states had more protection than the federal law. Like right now, sexual orientation is protected under the state law, but it's not protected. There isn't a specific statutory protection under federal law. Now they have EEOC through case law has argued that it is protected, but you still have that possibility that you'll have a Supreme Court that may reverse that. There is a challenge down on gender identity interpretation under that AEOC-ALJ made, that's pending before the Supreme Court. But you have those protections locally and statewide, and that's where you should concentrate, look at, and also look to where your challenges are going to be.
So like, what's your like legal ability to obtain information in cases where the person that's being accused of the discrimination like isn't willing to hand it over, I guess?
We have subpoena power,
Yeah.
so we'll get the information. We get it out of two ways, voluntarily or
Carrot or stick. Yeah.
So we do have subpoena
Take
power.
us there,
And that's for documents as well as, you know, people.
we can
So in
subpoena
case you
the
don't wanna come voluntarily, well,
person.
we'll get you here one way or another.
The subpoenas are enforced in court. We have to petition the court to enforce them. And since I've been there, we haven't lost an subpoena enforcement case before any of the circuit courts. Because we have a very broad, if it's relevant to the case, if we can show the relevancy, the court's gonna let us have it. So a lot of times, employers don't wanna give us personnel files, they said privacy, medical records, and we can have all of those things. And we do, if they don't turn them over, then we will serve them with subpoena. Most savvy employees will say, well, just for cover, just serve us with a subpoena so that we can say we're forced to give it to you.
Take you as the last question, right?
Yeah, so, am I right in understanding that if a person who is homeless is in a shelter and they feel discriminated by that shelter, unless that shelter receives, state funds or government funds, you can't necessarily go after them?
No, that's not true. If it's a place of public accommodation, then we can go after them.
Okay.
Or it may be housing.
Yeah, it could be
Because that's
housing
where
as
the
well, yeah.
person
Calls home.
dwells.
That's their dwelling. So it has nothing to do with the funding source.
Okay.
Under state law, it may be under federal law, but it's not under state law.
And just so everybody knows, one more quick thing in terms of, we talk about age, right? Under state law, when we cover age is not just 40 and over, right? So the federal law is 40 and over. With us under Title 20, we cover all ages, 40 and over and 40 and under. So if you feel like you're being discriminated against because of your age in terms of employment, because let's say older employees are being treated more favorably than you are, you still have a right to file. Now, you can't file federally, but you can file with us via Title 20 on the state law.
And age is not, if you notice, age is not a protected class under housing. There were two reasoning. One was a compromise, and then two, it was because they have senior housing and they provide those allowing exemptions for senior housing, that they didn't put age